What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And this time we take a look at the Kajan Johnson C.B. Dalloway antitrust lawsuit against Endeavor Zuffa, the UFC. Now, as we know, the Kung Lee antitrust lawsuit is coming to a head. The trial date is in April, and after that, we will see the Kajan Johnson antitrust lawsuit take place. Now, obviously, things could happen in between that time. There could be a settlement. There could be a verdict. There could be tons of other things. But like at this particular point, we're looking at a 2025 trial date, perhaps, for the Kajan Johnson lawsuit, which would stem from 2017 to the present time, as far as the timeline goes. Now, with that being said, a lot of things have, not a lot of things, but a couple things are being held over until the Kajan Johnson lawsuit, namely the injunctive relief portion of damages, which plaintiffs have indicated will occur at that particular point, so no injunctive relief in Kung Lee. Kajan Johnson will be talking about the damages from 2017 until the present time for fighters. And as a result of the acquisition by Endeavor of Zuffa, we get Endeavor actually filing this lawsuit. We get Endeavor filing this motion to dismiss as it relates to itself and any liability it might have related to the claims made by the fighters in the UFC. So, this is actually the third iteration of this motion to dismiss. The parties had agreed on the filing date, so this was filed on February 5th. We can expect a response in early March, and a reply about a week or so after that. As far as a hearing goes, we don't know. I would suspect maybe the summer, if the case is still going on, that we hear a motion to dismiss as a foreshadowing. I don't think that this motion will be granted on the part of Judge Boulware. I just think that there's too many things going on, too many issues that would indicate that he could dismiss it. So there's too many issues for him to dismiss it. Endeavor, in its motion here, tries to utilize the strategy that it is a organization that purchased Zuffa, and therefore there's actually no legal accountability on its part. Essentially, no legal accountability. Now, we could argue about, as a successor corporation, it knew about this lawsuit ongoing, but it indicates in its motion papers anyway that there is no way that Endeavor was at fault here. No claims made by plaintiffs about it. In its filing, it said that it would violate black-letter antitrust law to permit plaintiffs to circumvent the pleading failure by holding Endeavor vicariously liable for Zuffa's actions, merely because Endeavor acquired Zuffa during the pendency of a litigation alleging ongoing antitrust violations. It goes on to quote the Ninth Circuit by saying, it's long recognized that a parent or corporation cannot be sued directly simply because it owns a subsidiary's stock. So there's a bit of an argument there that you cannot sue someone directly and find proximate cause of a after acquired property. Of course, this is why organizations do due diligence and assess before acquiring an organization whether or not to accept it, because essentially you step in you step in for the organization that you are acquiring. So essentially, Endeavor is stepping in for Zuffa. Now, the question is, will the court buy this they're not vicariously liable argument? Well, we'll see. So Endeavor also goes on to argue that Zuffa and Endeavor are one and the same. Thus, unless plaintiffs can show an independent violation by Endeavor, the allegations must be dismissed. So they're saying that Zuffa and Endeavor cannot be the same. Excuse me, cannot be the same. Courts have confirmed that there's a doctrine called the Copperwell Doctrine that in no way allows a parent corporation to be held liable for its subsidiaries' alleged violation of Section 2 when the parent corporation's own conduct is not shown to independently violate the statute. Now, this provides an argument that no Section 2 antitrust violation, and they do in their motion papers make distinctions between monopolies and monopsonies. Again, remember this is a monopsony case, not a monopoly case. It's buyer side for those that it's easy to remember that way. So they're indicating that Endeavor itself must have shown some anti-competitive behavior, exclusionary conduct, and there is none. So that's how Endeavor sees itself out of this case. Now, obviously, plaintiffs have time to respond, and it seems too easy of a out for Endeavor to say, "Well, we didn't do this anti-competitive behavior. That's Zuffa." Well, they stepped in the shoes of Zuffa, so it's hard for them to escape that particular liability. Of course, what's happening here is they're arguing maybe a technical out here by indicating that Zuffa was the ones, if at all, that performed exclusionary conduct, and not Endeavor itself. And so they're basing that on the technicality that, again, it was Zuffa's anti-competitive conduct and not of parent corporation Endeavor. Obviously, this leads to issues and theories such as successor liability and other types of doctrines which would have the parent corporation liable for what the subsidiary corporation does. So there is that. Now, what comes next is the opposition brief by plaintiffs. And it will come at an interesting time because the trial for the Kung Lee case will be almost a month away, and you'll be dealing with a motion to dismiss in the Johnson case. So that'll be interesting. I thought I'd actually post something up about this just to let people know about what's going on in the Kajan Johnson case, as we actually will gravitate toward more of the Zuffa Kung Lee lawsuit coming up. It's Jason Cruz for The Legal Submission. Have a great one.